Hello, everyone. Our topic for this lecture podcast would be on judicial powers and in particular the prohibitions. In terms of the key outcomes of this lecture podcast, after studying this topic, you should then be able to discuss and explain the prohibitions and the vesting of judicial power in federal and state courts and distinguish and explain private and Ulster clauses and their validity. In particular, we're going to be focusing on three key themes. So one is the implication of the Boilermakers case, and we will get into that shortly. The second one would be the interaction of Section 51, subsection 39 of the Australian Constitution in relation to Chapter 3 of the Australian Constitution. And thirdly, as I said, we will go deeper into the idea of privative and Ulster clauses, both at the federal and state levels. So let's begin by looking at the implications of the Boilermakers case. We will recall that in the Boilermakers case, the High Court had made two important rulings on constitutional law. And the first one was that it was not permissible for a non-Chapter 3 court to exercise federal judicial power. So you cannot have a situation in that case where a non-Chapter 3 court, meaning a court that has not been constituted according to the requirements of Chapter 3, is able to exercise federal judicial power. That is not permitted under the Boilermakers doctrine. And the reason for that is that courts which are constituted according to Chapter 3 would require that they be appointed by the Governor General in Council. And there are clear requirements as to tenure, which means that they will have they must be permitted to serve up to the age of 70, and there can be no limitation on that tenure. So in other words, you cannot have a situation where a judge of a federal court is permitted to serve only, let's say, for a period of 5 years, or maybe even for a period of 7 years. And the other aspect of tenure is that there are clear grounds of removal of judges of federal courts. And we will examine this in particular later on. So that's one. So as I said, in terms of the Boilermakers case, the first key constitutional postulate is that federal judicial power cannot be exercised by courts which have not been constituted by under Chapter 3. And that is because it is important for the Constitution, under the Constitution, that Chapter 3 courts being the final bulwark of constitutionalism, that there be an independent judiciary that is insulated from interference of the executive or the legislature. Now, the other aspect is that under the Boilermakers doctrine is that it would not be permissible for a Chapter 3 court, meaning a court exercising judicial power, federal judicial power, to be vested with non-judicial functions, or what we call administrative functions, unless it is incidental to the judicial power, federal judicial power that is being exercised. So those two are the key principles of the Boilermakers case. But then this leads to some questions. So the first question we might ask is, can Parliament empower a federal court to delegate all or any of its powers to an officer of the court who is not a judge appointed under Section 72? And we will go through these specific questions in a short while. The second key question would be, can federal jurisdiction be exercised by officers of state courts who are not judges of such state courts? And thirdly, what are the limits to Parliament's power to appoint federal judges under Section 77, which is a provision on the power of Parliament to define the jurisdiction of Chapter 3 courts? So let's begin by looking at the first question. So can Parliament empower a federal court to delegate all or any of its powers to an officer of the court who is not a judge appointed under Section 72. So if you look at the Boilermakers case, because of the clear ruling and pronouncement of the High Court that only Chapter 3 courts can exercise federal judicial power, you would probably make the assumption that it has to be judges of those federal courts that should be permitted to exercise federal judicial power. In other words, it would not be permissible, following that logic, it would not be permissible for Parliament to empower somebody who is not an officer of a federal court to exercise federal judicial power. So the implication of the Boilermakers case seems to be that because only Chapter 3 courts can be permitted to exercise federal judicial power, it must follow necessarily by implication that it would be impermissible for someone who is not a judge of a federal court to be exercising federal judicial power. The one thing we have to remember, though, is that as far as federal courts are concerned, their judges typically are overloaded with cases. So it is not unusual for a federal court to be hearing as many as 20 or even 30 cases in a single day. And in other words, a single federal court may be handling so many cases that if a judge were to individually and personally issue orders in relation to each of those cases, it will take a long time for a case to be resolved. And so oftentimes there are instances when it seems to make sense for certain functions of judges to be delegated to an officer of the court, but who is not a judge. And this can be in the case of a registrar or a deputy registrar of the court. So for example, as far as consent orders are concerned, what typically happens in relation to consent orders is that two parties or the parties in a case may come before the court and saying that they have reached an agreement in relation to the case and in relation to how they might end up settling the case or how the case may proceed in the meantime prior to a final determination by the court to be made. So they basically come up with an agreement, whether that becomes the final binding agreement that is conclusive of the matter, or it is a consent order that just puts down in writing an agreement of the parties as to certain matters concerning the case. And in fact, in most cases before the courts, consent orders are obviously encouraged because it cuts down on the time for the resolution of the case, and it allows the parties to come up with a binding agreement on their own without the court having to intervene as to the intricacies of every single order. So that's one. The other aspect we have to remember is that under Section 77, the Parliament has the power to make laws which would define the jurisdiction of any federal court other than the High Court, and it also has the power to define the extent to which the jurisdiction of any federal court shall be exclusive of that which belongs to or invested in the courts of the states. And on the basis of this power, it is permissible, therefore, in a sense, for Parliament, for the Commonwealth Parliament, to kind of appoint non-judges or who are officers of a federal court to undertake certain judicial functions. But as I said, that would be in conflict somehow with the Boilermakers case. So let's speak of a good example where you might have a situation where Parliament passes a law saying that the registrar of a federal court has the power to issue consent orders, meaning validate an agreement between parties of a case that might resolve issues on property relations, or that might really resolve issues concerning specific contracts. And so in other words, in that case, it will be the registrar or the deputy registrar under that specific enactment of the parliament who will then be issuing a consent order. And typically, as we've said, consent orders would involve the exercise of federal judicial power, and therefore it is typically exercised by federal judges. But what if Parliament says or states that non-judges, in this case deputy registrars or registrars of the court who are not judges, would be permitted to issue consent orders? Would that be valid? So in the case of Harris versus Calladine, the wife questioned the delegation of certain judicial powers to the registrar of the federal court, because she was of the view that, according to the Boilermakers case, it would be impermissible for the Commonwealth Parliament to vest federal judicial power in officers of the court who are not judges of a Chapter 3 court. So in other words, if the Boilermakers case made the point that it is impermissible for the Commonwealth Parliament to vest judicial power in non-Chapter 3 courts, then it could also be argued that it would be impermissible for the Commonwealth Parliament to vest judicial power in someone who is not a judge of a Chapter 3 court. So that was the argument that she was making. But the High Court ruled that it is actually permissible for Parliament to vest judicial power in an officer of the court who is not a judge, for as long as the exercise of the power by a delegate of the court is still subject to the final approval of the court itself. So for as long as the federal court itself was in a position to actually review or make changes to the orders issued by an officer of the court who is not a judge, then there was nothing impermissible with that delegated authority made by the Commonwealth Parliament. So that's one. Now, the second question that we then need to look at would be whether or not federal jurisdiction can be exercised by officers of state courts who are not judges of such state courts. So Harris versus Calladine looked at the delegated authority of non-judges of a federal court to exercise federal judicial power. This time, the basic question is, can federal judicial power be exercised by officers of state courts who are not judges of such state courts? Now, this specific question was raised in the case of Commonwealth versus Hospital Contribution Fund, where the Commonwealth challenged the power of an officer of the New South Wales Supreme Court, called a master, to hear and determine the claim to privilege against the production of documents in the possession of the Commonwealth Minister for State Health. The Commonwealth had argued that in the case of Kotsis versus Kotsis and Knight versus Knight, in previous cases, it had been the ruling of the court that it was impermissible for a non-judge of a state court to be exercising federal judicial power. In this case, however, in the case of Commonwealth versus Hospital Contribution Fund, the High Court ruled that it was in fact overruling, in other words, the decision of Kotsis versus Kotsis and Knight versus Knight. The High Court ruled that it was in fact permissible for the Commonwealth Parliament to allow a non-judge of a state court exercising federal jurisdiction to exercise federal judicial power. And the reason for this is that allowing officers of a state court who is not a judge of that state court does not actually diminish the independence of the state courts in the first place. And remember, the independence of state courts, especially at the state level, is crucial because of the absence of a separation of powers at the state level. But the High Court noticed, specifically according to Chief Justice Gibbs, that it was already possible for state courts in the first place to have as judges those who are not even lawyers. So you could have a layman who is a judge of a state court. And so in that case, because they are laymen, there's also a likelihood that they may in fact be appointed as judges of a state court without security of tenure. So unlike the constitution of a Chapter 3 court, where there is a clear requirement that there should be security of tenure of judges of federal courts under Section 71 of the Australian Constitution, at the level of states, there is no requirement that judges of state courts must have security of tenure. So they could just be appointed, for example, for 5 years or even for 3 years, or they may be appointed in an acting capacity. And so the point that the Chief Justice Gibbs said was that if state judges in the first place can possibly not have security of tenure, and therefore to an extent may actually be susceptible to interference by the executive of the state or by the state parliament, then there was nothing that would also put into question the empowerment of an officer of a state court in exercising federal judicial power. Because in the end, even such an officer of a court, of a state court, will not actually be exercising his own power. He's actually exercising the powers of the state court itself. So therefore, it is subject to a review and subject to supervision of the judge of the state court itself. So in other words, the exercise by that officer of a state court is not according to his own account, but he's actually exercising the jurisdiction and the power of the state court itself. Again, as a reminder, or as a review, under Section 71 of the Australian Constitution, federal judicial power is vested in the High Court, which is the Federal Supreme Court of Australia, and in such other federal courts as the Parliament creates, as well as in such other courts as it may invest with federal jurisdiction. So this would therefore enable the Commonwealth Parliament to authorize state courts, for example, to be invested with federal jurisdiction. So that's just a kind of a review. But then again, it raises the question of, as well, of looking at, for example, specifically at Section 77 of the same Constitution. Under that same provision, the Commonwealth Parliament has the power to define the jurisdiction of any federal court other than the High Court. Would it mean therefore, that given its power to define the jurisdiction of a court, it would actually also be permissible for the Commonwealth Parliament to also control the appointment of federal judges. So, looking at Section 77, the basic question is, would the Commonwealth Parliament actually have a power to appoint federal judges that do not fit the requirements of Section 71 of the Australian Constitution, especially concerning who appoints them, for example, and as to the issues of tenure. So, for one, the question might be, would it be possible for Parliament to directly appoint a judge of a federal court without an appointment being made by the Governor-General in Council? Or would it be permissible, for example, for the Commonwealth Parliament to enable the Prime Minister to directly appoint a judge of a federal court? And on this basis, the attempt of the Commonwealth Parliament in this regard to make such an appointment would be Section 77, because it has the power under that provision to define the jurisdiction of the federal court. So if it can define the jurisdiction of the federal court, then it could be argued that it would also have the power to define the appointment and the qualifications and even the tenure or the term of office of judges who are appointed in a federal court. The other question that we can have will be, would it be permissible for a Parliament to enable the appointment of a judge of a federal court, let's say for a term of only 3 years, or even in an acting capacity, or that there's a requirement that a judge of a federal court that has just been created by Parliament will have to satisfy certain requirements, in the sense that they should be able to, that their performance can be reviewed, the speed by which they make decisions can be reviewed. And so, in other words, if they fail to meet certain performance standards, they could then be removed. So these are some of the questions that can be asked. But the clear implication, however, of Section 71 of the Australian Constitution is that in relation to the appointment of judges of federal courts, those judges must be appointed according to the strict requirements of Section 71. So in the first place, the judges of federal courts must have to be appointed by the Governor-General in Council. So it would not be permissible for the legislature itself to make the appointment, or for the Prime Minister to make the appointment of a judge of the federal court. Only the Governor-General in Council can do that. It would also mean, therefore, that the Minister of Justice would not be permitted to appoint a judge of a federal court. And not even the Chief Justice of the High Court of Australia would have the power to appoint a judge of a federal court or of the High Court itself. The other implication of this is that it would not be permissible for the Commonwealth Parliament to provide for other ways by which a judge of a federal court can be removed from office. Because if you look at the specific provision of Section 71 of the Australian Constitution, they may only be removed on the grounds of misbehavior or incapacity. So in relation to misbehavior, for example, it could be it's a broad statement, but it could be about the commission of a crime by a federal judge, or it could be because of the commission of an act which is deplorable or deemed highly unethical. So this could be a ground. But or if there were another ground, because let's say it's on the basis of a poor performance, as stated by the Commonwealth Parliament, that would not be permissible, because that is not a ground that is allowed or provided for under Section 71 of the Australian Constitution. What it also means is that the tenure of judges has to be permanent, in the sense that that a federal judge must be permitted to serve, unless removed according to the grounds of Section 71. They must be permitted to serve in a federal court up to the age of 70. So it's not permissible therefore for there to be an appointment of someone in an acting capacity, because in that case there is no permanent appointment, and neither would it be permissible for the appointment of a judge of a federal court solely for a fixed term of, let's say, 3 years or 5 years. Now, moving on, let's examine the interaction of Section 51, subsection 39 of the Australian Constitution in relation to Chapter 3 of the Constitution itself. Because if we look at Section 51, subsection 39, it would seem that there seems to be a head of power which enables the Commonwealth Parliament to create federal courts that do not meet the criteria or the requirements of Chapter 3. In particular, Section 51, subsection 39 provides that the Commonwealth Parliament has the power to make laws for the peace, order, and good government of the Commonwealth with respect to matters incidental to the execution of any power vested by this Constitution in the federal judicature. So the point being, does this provision provide a power to the Commonwealth Parliament apart from its power under Section 77 of the Australian Constitution, which under the Australian Constitution, which is the power to create federal courts? Does this section 51, subsection 39, provide for another mechanism or another power or authority on the part of the Australian Commonwealth to create federal courts that do not meet the requirements of a Chapter 3 court? And this goes back to the question of, issues about age, whether a federal court can be created under this particular section, Section 51, subsection 39, whether a federal court can be created where a judge of such a federal court may be older than 70 years of age, or that a person can be appointed in such a federal court under Section 51, subsection 39 of the Australian Constitution, where he is appointed only for a fixed term, let's say of 3 years or 5 years or even 10 years. So that's the basic question there. But the High Court has been quite clear in saying that under the clear provisions of Section 71, there are only 3 kinds of federal courts that the Australian Constitution envisages. And one of them is that it is the High Court of Australia, which has federal judicial power. 2, it would be federal courts as the Parliament creates, but it has then to be an appointment according to Chapter 3. And thirdly, will be the vesting of federal judicial power in such other courts as the Parliament determines. So in other words, for example, it may be permissible for Parliament to vest federal judicial power in state courts. But Section 51, subsection 39, does not provide or authorize the Commonwealth Parliament to create federal courts outside of the stringent provisions of Chapter 3 of the Australian Constitution. So in that case, therefore, it would be impermissible, going back to the statements I made earlier, it would be impermissible for the Commonwealth Parliament, citing Section 51, subsection 39, it would be permissible for the Commonwealth Parliament to create a federal court where the judges can only serve for a fixed term, or that they're serving on in an acting capacity, or where judges may be appointed are subject to the control or direction of the executive or of the Parliament, or that they can be appointed subject to certain performance standards. So that would not be permissible, because Section 51, subsection 39 does not provide a separate source of power in relation to the creation of Chapter 3 courts. In other words, the High Court pointed out that the Chapter 3 is an exhaustive list. It is a full list of the kinds of federal courts that can be that the Australian Commonwealth can have. So there can be no other courts exercising federal judicial power other than those that are to be created or that exist according to Chapter 3 of the Australian Constitution. And that also raises the question, because of Section 51, subsection 39, would it be permissible for Parliament, for example, to confer jurisdiction on the High Court? Or even according to Section 77 of the Australian Constitution, which empowers the Commonwealth Parliament to determine jurisdiction, to define the jurisdiction of federal courts. Would it be permissible, for example, for the Australian Commonwealth Parliament to confer jurisdiction on the High Court or on any federal court on a question of law that might be referred to by the Governor General as to the validity of any act or enactment of the Parliament? In other words, would it be permissible for the Commonwealth Parliament to authorize a federal court to make a judgment or determine questions of law, even in the absence of an actual controversy or even in the absence of a matter? In other words, would it be permissible for the Commonwealth Parliament, citing Section 77 of the Australian Constitution, or even Section 51, subsection 39 of the Australian Constitution, would it be permissible for the Australian Commonwealth Parliament to enable or to authorize that federal courts would be permitted to provide a judicial determination on hypothetical or theoretical issues which do not involve matters? And the High Court has ruled that that is not permissible, that would not be allowed, because under Section 75 and Section 77 of the Australian Constitution, the federal courts can only exercise their federal judicial power in relation to matters. So even Section 77 is quite clear that the power of Parliament to make laws can only be made with respect to any matters mentioned in the last two sections, meaning Section 75 and Section 77. So the other question that is raised here is whether or not it would be permissible for states to authorize federal courts to exercise state judicial power. We must remember that the Australian Constitution, as part of cooperative federalism, it allows states to vest certain powers to the Australian Commonwealth Parliament, even when such a power may not lie with the Commonwealth Parliament under Section 51. So, for example, even if, as we will see later on in the next week concerning federal-state relations, even if the power concerning making laws in relation to certain crimes, or the power over education, or the power over the environment, exclusively lie with state parliaments, the Australian Constitution actually recognizes the power of state parliaments to vest certain state parliamentary powers to the Commonwealth Parliament, so that the power of the Australian Commonwealth Parliament goes beyond that which is provided under Section 51. So in that case, the question then is, would it be permissible as well for state parliaments to authorize the Commonwealth Parliament to pass a law that would allow federal courts to exercise state judicial power. In the same manner that state parliaments are actually permitted to expand the power of the federal parliament to legislate on matters beyond Section 51 of the Australian Constitution if the state parliament authorizes this. And this is part of what is known as cooperative federalism. But the High Court ruled in the case of R. Wakeham, ex parte McNally, R versus Wakeham, ex parte McNally, that although cooperative federalism is permissible under the Australian Constitution, there is nothing on the Australian Constitution, however, which would authorize federal courts to exercise state judicial power. So that would not be permissible. So, in other words, while it may be permissible on the one hand for state courts to be allowed by the Australian Commonwealth Power to exercise federal judicial power, the reverse is not true. It would not be permissible for state parliaments to authorize federal courts to be exercising state judicial power. Okay, so that hopefully is clear. So on the one hand, even if the Australian Constitution permits the Commonwealth Parliament to pass a law that would authorize state courts to exercise federal judicial power, the reverse is not true. State parliaments are not permitted to authorize, state parliaments or the Commonwealth Parliament, or for that matter, are not permitted to invest federal courts with state judicial power. That is not permissible because the powers of federal courts are clearly provided in Chapter 3 of the Australian Constitution, and there is nothing there that would indicate that the delegation of state judicial power in federal courts is permitted. So that is the ruling in R. versus Wakeham, ex parte McNally. So even if state courts allow it as part of cooperative federalism, and the Commonwealth Parliament itself also therefore passes legislation to that effect, it would not be permissible for a federal court to be exercising state judicial power. Now, the other question that is relevant there is the limits of the power of state parliaments to confer non-judicial power on state courts. So we must again remember that because of the absence of the doctrine of separation of powers at the level of states, it is actually permissible for judges of state courts to exercise non-judicial powers. Obviously, this kind of arrangement is not tolerated at the level of federal courts, because following the Boilermakers doctrine, it is impermissible for a federal court to be exercising non-judicial power. But this prohibition does not lie or is not present in the case of state courts because of the absence of separation of powers in state courts. It is permissible for state courts to be exercising non-judicial powers. But the question is, are there limits to the power of state parliaments to confer non-judicial powers on state courts? And we should be reminded that the ruling of the High Court, both in the case of the Boilermakers doctrine as well as Victorian stevedoring and General Contracting Company Proprietary Limited versus Dignan, or the Dignan case, that there are limits to what state courts can do in relation to the conferment of non-judicial powers on state courts. The High Court would not tolerate a situation where the vesting of non-judicial power on state courts which are exercising federal judicial power, would then impair the essential characteristic of a court as a court exercising federal jurisdiction. So in that case, when such a state court exercising federal jurisdiction begins to become an instrument of the state executive or the state parliament, or its independence can clearly be questioned, then that would not be tolerated, because under the autochthonous doctrine as stated by the High Court, even state courts, when they become invested with federal jurisdiction, are part of an integrated judicial system under Chapter 3 of the Constitution. So following the clear decision of the High Court in Wainohu versus New South Wales, notwithstanding the lack of a separation of powers at the level of states, it is not permissible there are limits to the power of state parliaments to confer non-judicial powers on state courts. So finally, let's look at the situation concerning privative versus Ulster clauses. And we will try to look at the difference between the two. We will begin by examining the case of R versus Hickman, ex parte Fox and Clinton. And in that specific case, the Commonwealth Tribunal, which had been created by the Commonwealth Parliament. So the Commonwealth Tribunal in this case was not a Chapter 3 court. It was an administrative body, therefore belonging to the executive. But in this case, this specific Commonwealth Tribunal had the power to make decisions concerning the employers and employees in the coal mining industry. And it had the power to issue orders in relation to the minimum wages that were to be followed or given in that specific industry, and that the decisions or orders made by the Commonwealth Tribunal, by that Commonwealth Tribunal, would then be binding on the companies that are part of the case, which is before that specific Commonwealth Tribunal. But in that specific legislation that created the Commonwealth Tribunal, it was also stated that the tribunal's decision shall not be challenged, appealed against, quashed, or called into question, or be subject to prohibition, mandamus, or injunction in any court on any account whatsoever. And again, we look at that specific wording of the legislation in relation to Section 75 of the Australian Constitution, which clearly grants the High Court the power to grant a writ of prohibition, mandamus, or injunction against officers of the Commonwealth. So the question is, given that prohibition made by the Commonwealth Parliament in relation to the tribunal's decision that these decisions shall not be challenged, appealed against, quashed, or called into question, or be subject to prohibition, mandamus, or injunction in any court on any account whatsoever, would that provision be invalid? Now, in the case of R versus Hickman, the High Court actually validated the limiting provisions of that particular law, so that the High Court said that that was a valid limitation on the power of federal courts to review decisions of the tribunal. And there were three things that were crucial that would have to be shown, however, for that specific limiting clause or prohibiting clause to be valid. One was that the tribunal must have attempted to exercise its power bona fide, meaning in good faith. Two, that the exercise by the tribunal of its power was in relation to the subject matter of the legislation. And thirdly, that it was reasonably capable of reference to the power given to the tribunal. So in other words, the exercise of the power can actually be connected to a power that was referred to in the enabling law. So that also means that where the power has not been exercised in good faith, or that the decision of the tribunal was on a subject matter that was not found in the legislation, or that the exercise of a power was beyond the power authorized by the statute, then in that case, the prohibition, the limiting clause of the law would not have been permissible. So what the High Court then did was a matter of construction or interpretation, that for as long as these three elements were present, then the limiting clause would be valid. But otherwise, if the law, for example, insulated or immunized a decision of a tribunal so that the High Court or the Federal Court would not have a power to issue a writ of mandamus or prohibition or injunction, even in instances when a tribunal exercised a power in bad faith, or that the tribunal made a decision in relation to a subject matter that was outside of the legislation, or that the tribunal exercised its power ultra vires, then the High Court said that would not be permissible. So it was then a question of interpreting the statute. So for as long as it was interpreted in such a way that the three elements were there, meaning one, that the exercise of the tribunal's power was made in good faith, that the subject matter of the decision was within the legislation, and thirdly, that the exercise of the power was spelled out and within the terms of reference of the enabling legislation, then that clause would be considered valid. And in that case, that would be considered a privative clause. But a clause that would totally immunize or insulate a decision of a tribunal, such that even when a decision is ultra vires, or where a decision made by the tribunal is done in bad faith, and to see that that is beyond the power of the courts to review, that would not be permissible, because that would then be an ouster clause, and it is not within the power of the Australian Parliament to oust the High Court of its jurisdiction that is provided for in the Constitution. And so there is another case which we're looking at here. Would it be valid, for example, for Parliament to pass a law that would prohibit federal courts from ordering the release from custody of a designated person detained by an officer of the Commonwealth Executive? So this specific question came up in the case of Chu Keng Lim versus Minister for Immigration, Local Government and Ethnic Affairs, where the Australian Commonwealth Parliament passed legislation which expressly provided that no court, including the High Court, could order the release from custody of a non-citizen who had been detained or imprisoned for violating the laws of Australia, particularly, for example, the laws on immigration. So it was not permissible for any court, federal court, including the High Court, to release from custody such a person. And so if you follow the ruling in R versus Hickman, we would assume that such a limiting provision would be valid. However, the High Court ruled that because of the demarcation of powers under the Australian Constitution, where you have the executive, you have the legislature, and the judiciary, it was not within the power of the Australian Commonwealth to delimit the power of federal courts or the power of the High Court, where such a power was clearly provided in the Australian Constitution. So that where the exercise of a power by the executive was actually ultra vires, meaning beyond power, or its exercise or the exercise of the power by the executive was not done in good faith, such an act would be void and was actually within the scope of the power of federal courts, including the High Court, to invalidate. And so it was not within the power of the High Court ruled in Chukeng Lim versus Minister for Immigration, Local Government and Ethnic Affairs, that it was not within the power of the Australian Commonwealth Parliament to oust or deprive the High Court or a federal court from its original jurisdiction to issue writs of mandamus, prohibition, or injunction. At least the High Court cannot be deprived or ousted of its inherent jurisdiction under Section 75 of the Australian Constitution. The other relevant case in relation to privative and ouster clauses would be the case of Plaintiff S157/2002 versus Commonwealth, where the Australian Commonwealth Parliament, in creating the Refugee Review Tribunal, which is an administrative body, not a Chapter 3 court, where that enabling law provided that certain decisions of the Refugee Review Tribunal were not reviewable even by the High Court. And again, if we look at the case of R versus Hickman, it would seem that this would be permissible. The High Court ruled that for as long as the exercise by the tribunal of its powers was within jurisdiction, meaning one, that it exercised a power that was provided for in the legislation, and two, the exercise of such a power was in good faith, and three, according to R versus Hickman, that the decision related to a subject matter that was provided for in the enabling act. In those three instances, were they to be present, then the limiting clause would be valid, and therefore, in that case, the decision of the Refugee Review Tribunal would not be reviewable by the High Court. However, if the decision of the Refugee Review Tribunal was beyond jurisdiction, or that the decision was in exercise of a power that was not allowed in the legislation, or meaning that it was ultra vires, or it was done in good faith, or it was on a subject matter that was not found within the enabling law itself, then the High Court ruled that it cannot be deprived of its inherent power under Section 75 to issue writs of mandamus, prohibition, or injunction against any officer of the Commonwealth. So in this particular case, that specific provision that created the Refugee Review Tribunal, which stated that certain decisions of the tribunal may not be reviewed by courts, including the High Court, would only be valid for as long as it was it was made within jurisdiction. And so in that case, the act, therefore, was considered valid by the High Court. And so we will see that this specific provision of the act was only deemed valid and constitutional by the manner by which the High Court interpreted it, that the decisions of the tribunal were within jurisdiction. But had the decisions of the tribunal been made outside of jurisdiction or in excess of jurisdiction, because one, it did not have the power, or the power was exercised in bad faith, or the subject matter of the decision was not within the terms of the legislation, then the inherent power of the court to issue writs of mandamus, prohibition, or injunction against an officer of the Commonwealth cannot be removed from the powers of the High Court. So after studying this topic, it is hoped that you should then be able to discuss and explain the prohibitions in the vesting of judicial power in federal and state courts, and then distinguish and explain privative and ouster clauses and their validity.